नमस्कार दोस्तों 19 December 2024 we are going to discuss editorials from The Hindu. Wherever good articles are there, we will take those articles, we will discuss those articles, we will analyze them and we will find what could be important for us. Without further delay, we will go into article discussion. First article here, it is about section 6A of the Citizenship Amendment Act. Why it is failing in state of Assam. We'll discuss this article in detailed manner. There was a constitutional ruling 4:1 majority on October 2024. They upheld the constitutional validity of the section 6A of the Citizenship Amendment Act. This is very significant. When you talk about section 6A, what is this? This provision basically it establishes distinct framework for migrants from the former East Pakistan who settled in Assam, allowing them to acquire Indian citizenship if they arrived before March 25, 1971. Those who have arrived before March 25, 1971 from today's Bangladesh, that means present Bangladesh or previous East Pakistan, they can get Citizenship Act from India. However, if they arrive after March 25, they cannot get citizenship. So it is very worth to analyze the judgment because there are several constitutional violations that were overlooked by majority decisions. Also, there are negative implications of ruling. See, this article you can understand right away that they are against the judgment of the Supreme Court. They will give all the negative views. Basically, most of the time, articles from the Hindu, they might be against BJP, they may support some other party, but we don't need to worry about all those things. First thing, the judgment suffers from arbitrary reasoning. The then Chief Justice of India, D.Y. Chandrachud, he justified the test of Article 14. What is Article 14? Equality before law, equal protection of the law. Taking out Assam against other states, he told, though other states such as West Bengal, Meghalaya, Tripura, Mizoram, they all share border with Bangladesh. Compared to Assam, the magnitude of people who came into Assam and its impact on the cultural and political rights of the Assamese people, tribal population, it is very high. The impact of 40 lakh migrants in Assam, this may be greater than impact of 57 lakh migrants in West Bengal. Why? Assam's lesser population, Assam has a less land area when compared to West Bengal. So, therefore, the single outing Assam based on rational considerations. So, this is just overall consideration. But when you test other laws such as Article 29, what is Article 29? It protects the culture, educational institutions and all. Court told the incoming of the people that did not affect language, script, culture of the Assamese people, nor even it did affect ability to protect the same. A same examination of the contradictory reasoning, this tells the judgment was crafted to support the provision rather than evaluate against the constitutional principles. So we need to understand the judgment in great detail. When you consider section 6A of the Citizenship Amendment Act, it was introduced in 1985. There was a famous accord called Assam Accord. There was an agreement reached between Government of India and leaders of the Assam movement. The movement came in response to migration from East Pakistan, today's Bangladesh, into Assam. This brought many concerns because people felt that their local culture, their economic strain and then political, there was a huge imbalance. This Assam Accord, they wanted to resolve these issues by putting specific cutoff date to the people who are coming into Assam in the state of Assam from East Pakistan or today's Bangladesh. Those who have come before Jan 1st, 1966, even till March 25, 1971, they can be granted citizenship. So, they should have the 10 years of residence in Assam. After this March 25, 1971, all these people they declared illegal migrants. Then they were to detection and deportation. So there are several gaps in the reasoning. There are several constitutional drawbacks in the section 6A of this Constitutional Citizenship Amendment Act or Citizenship Act. There is a violation of Article 29 of the Constitution. Basically, this article talks about cultural and linguistic displacement. Article 29 of the Indian Constitution, this guarantees protection of the distinct culture, linguistic identities within India. During this ruling, court even held that Section 6A, this is what not violative of the Article 29. This basically mere presence of the different ethnic groups in the state does not automatically infringe upon the cultural rights guaranteed by the Constitution. Even court said Article 29 subclass 1 this give right to conserve culture. Even it is interpreted as allowing sections of citizens to take protective and positive steps in order to protect their language, script, culture. Even that laws they must not prevent such efforts. Court even emphasized the petitioner failed to provide kind of flow of migrants that was facilitated by Section 6A. Basically, this prevented Assamese people ability to take steps to conserve their culture. But if you can understand the reasoning, this is completely flawed. Court even laid emphasis on abstract right to conserve culture. Court basically overlooked the fact that provision creates prevention of the people to meaningfully preserve their culture and their cultural identity also. Even court failed to observe formal recognition of the right to conserve culture is insufficient. If state allows circumstances to come up that kind of erode culture that seeks to protect their own culture. Even there was research by several people, these things will also tell the same. Even one of the most striking constitutional flaws of the Section 6A of the Citizenship Amendment Act is that there is temporal unreasonableness. If you can consider doctrine of manifest arbitrariness. These laws, they are constitutional at the time of enactment. They can become unreasonable over time because of the changing circumstances. Section 6A is also kind of same thing. This law lacks a temporal limitation on its operation. This allows individuals from several streams to apply citizenship infinitely. More than 40 years after cutoff date, this law still remains in force. This helped ineffective addressing of the original problems it was designed to solve. What do you feel? आपको क्या लगता है? कोई बाहर से आए फिर हमारा कल्चर को गंदा किया जाए तो आपको अच्छा लगता है? What I feel is this article basically they are supporting people, but overall if you can see humanity, we must go from humanity point of view. From times immemorial, we have accepted several culture. Looters, basically the Mughals, they came, they settled in India, they ingrained into our culture. There are several people who have come from different parts and then they have settled in our country. But in modern days, country with 140 billion population, we should generate enough resources, employment opportunities must be created. So it will become a huge task. Basically, those tribal population, those local people who are living in Assam, their culture may be damaged basically. Whether people are concerned about or not, these articlists, whoever Ravi Singh, Chikara or Anoy Roy, these people, I don't know whether they are concerned about these things. लिखने के लिए तो कुछ भी लिख सकते हैं. There are even they are telling faulty mechanisms that are going to impact. Basically, the mechanism for identifying and processing the migrants who comes under Section 6A, it is kind of flawed. अब ये बता रहे हैं कि जो लोग आते हैं बाहर से उनको आइडेंटिफाई करने के लिए जो भी मैकेनिज्म डिज़ाइन किया गया उसका इम्पैक्ट क्या कुछ होगा, ये सब गलत है करके बोल रहा है और गलत तरीके में किया गया. तो ऐसे नहीं होता है ना. इवन वी नीड टू अंडरस्टैंड कोर्ट whenever they write judgment to justify enactment of this Section 6A, the ruling fails to address key constitutional concerns. Basically, those regarding cultural, demographic impact, Assam indigenous population, Even the judgment, they overlooked how migration eroded linguistic and cultural identity of the Assamese people. Basically, it violated Article 29 of the Protective Intent. So basically, so that's it about this article. So basically, they are just criticizing court decision on Section 6A of the Citizenship Act. तो जहाँ तक देखे जाए, so there are certain issues, but these issues need to be understood in clear manner. So we'll go to next article. Next article, we will discuss about strengthening roots of the agriculture and carbon market. Basically, we will call agri-carbon market. In these days, there is a huge focus on climate change. Impact of the climate change has been growing, and there is a Paris climate change and a Paris Accord also. With that, even we have sustainable development goals. Sustainable development, one of the goal, life on land, life below water, we need to protect them. And also, climate change is also one of the element of the sustainable development goals, which are 17 in number. They have to be achieved by 2030. So in this respect, this article will become very, very important from agricultural carbon market. Carbon market, it has potential to transform Indian agriculture. It can transform agriculture by bringing sustainable practices, and they help farmers in directly combating climate change. Carbon pricing, if you can understand, this is very important tool in order to prevent climate change. This carbon pricing, this functions through basically compliance and voluntary carbon markets. What do you mean by compliance? If you see compliance market, they are regulated by government or international bodies. For example, United Nations, they impose emission caps on companies. Those businesses that exceed these caps, they must either purchase carbon credit from projects that prevent greenhouse gases emission, such as agroforestry or sustainable agricultural project, or they have to pay carbon taxes for their extra emissions. In difference, basically, the voluntary carbon market, now we discussed about carbon pricing market. When you see voluntary carbon market, this operates without any regulations. This will allow organization in order to trade carbon credits. There are certain mechanisms are there, clean development mechanism, Vera, gold standard. There are several such things are there. So together, these systems, they basically aim to reduce greenhouse gas emissions. Even they support global climate goals also. If you understand the carbon markets and their working, carbon markets are becoming very, very important, and they are gaining huge momentum these days. In Conference of Parties 29 on November this 2024, there was a centralized carbon market under United Nations that kind of got a green signal. Last year, our country, India, we announced we would launch our own compliance and voluntary carbon market. Recently, if you see National Bank for Agriculture and Rural Development, that is NABARD, in collaboration with Indian Council of Agricultural Research and state universities, they listed 5 agricultural carbon credit projects in Vera. Carbon market, they rely on 2 key principles. They ensure additionality and they ensure permeance. What do you mean by additionality? Additionality basically means it ensures emissions reductions happen only because of the carbon credits. This will help farmers to adopt new practices. That means those who are already use of these sustainable methods, they are not eligible for these credits. What do you mean by permanence? Permanence means long-term durability of these benefits. Permanence guarantees such kind of things such as ensuring carbon stored in soil through reduced tillage, because carbon will go into land and then it will stay there. If you do tilling and all for agricultural purpose, kind of ploughing and all, then carbon will come out. These kind of projects, therefore, they must aim to generate trade carbon credits and they must adhere to certain conditions, including this additionality and permanence. In order to understand India's readiness to agricultural sector for full-scale carbon market, we need to examine existing carbon credit projects that are listed under non-governmental credits, which are those, that is one project name is Vera. These projects will highlight challenges and necessary fixes before we go for scaling up. If these projects they fail to deliver promised environmental benefits such as producing unreliable credits, those kind of buyers they may lose confidence, they stop purchasing agricultural carbon credits. This will deprive farmers of their extra income. It will discourage adoption of these kind of sustainable practices. Every time we talk about doubling farmers income, these are all the methods where we can explore in Indian market. We need to ensure high quality credit from the start of Indian carbon markets. It is very crucial for trust, even long-term farmer participation. In just 4 years, 50 agricultural carbon farming projects have been listed under Vera. This targeted 16 lakh hectares of the farmland in India. These projects they aim to generate approximately 4.7 million, that means 47 lakh carbon credits annually. That means this is equivalent to setting greenhouse gas emitted from 11 billion miles that are driven by average gasoline powered vehicles, that means petrol vehicle. But none of these projects is registered, that means carbon credit they have not been issued, and farmers didn't receive any money. What to do in carbon farming projects in India? There was a recent study by writers of this article. They published an article, Climate Policy, basically carbon farming in India. What are all the existing projects that are inclusive, additional and permanent? This article, divides and understands 7 such carbon farming projects in Haryana and Madhya Pradesh. They focus on socio-economic inclusiveness, even additionality and permanence. The finding from this article shows marginalized community, even small farmers, they were largely excluded. Even with women, they are making barely 4% of the participants. Carbon markets in this state, they cultivated significantly more land, 51% in Haryana, 32% in Madhya Pradesh, than non-carbon farmers. Among these non-carbon farmers, 46% of the land was owned by non-marginalized castes such as general caste, 17% by scheduled caste and scheduled tribes farmers. But among these carbon farmers, 63% of the land they come under non-marginalized cases. Only 13% is owned by SC/ST farmers. If you understand further, there are sustainable practices that were already placed before this project began, such as zero tillage, alternate wetting and drying, intercropping, reduced chemical fertilizer use, micro irrigation, tree planting. These are newly adopted. This satisfies additionality condition. These things will demonstrate when these things are implemented effectively, the project can genuinely reduce greenhouse gas emissions. There are significant challenges remain in these projects because 45% of the farmers they reported no communication. Even 60% of them lacked training in new techniques. 28% stopped sustainable practices by second year because of the insufficient financial incentives. If you see, alarmingly, 99% had not received carbon credit payments, even with additional issues including yield penalties, inadequate information on carbon farming. Despite these setbacks, projects managed by startups they focus solely on carbon credits. They termed them as carbon core. And then these projects were less inclusive of smallholders, even marginalized communities also. To address this issue, India's carbon market, they must incentivize socially inclusive projects by offering higher prices for carbon credits from projects that include basically smallholders and marginalized communities. Effective communication, regular training, even guaranteed timely payments, they can enhance farmer participation. Collaborating with national, international research institutions to target specific kind of regions and intervening can prevent yield penalties, even protect food security in the country also. How science is improving? The science of measuring soil carbon, greenhouse gas, they are expected to improve over time. In recent years, digital technology, they have advanced significantly. There are several tools are there, remote sensing, satellite imagery, drones, sensors. They are used for monitoring project activities that will become more accessible. But for carbon markets, in order to succeed, the critical focus must be addressing the grand old implementation of these challenges. Building thriving agricultural carbon market in India, it requires collaboration among policymakers, researchers, private entities to ensure there is a inclusivity, transparency, timely rewards for farmers, even improved project implementation also. This is the particle about agri carbon market. We will discuss next article. This article is about making generic medicines more reliable and then more affordable. We will discuss this article. What do you mean by generic medicines basically? Suppose say I am person A, I do some kind of research, I do all clinical trials. It will take almost 10 years for me in order to invent some drugs for disease. Let us suppose say I am inventing a drug for AIDS. Then what I will do, I will go and I will patent it. I will get the intellectual property rights. Then those 10 years, the amount of money I have spent, even amount of efforts I have put, so I will decide the price. Then government will give me rights for almost 25 years. So in 25 years, if you sell those drugs to patients who are suffering from AIDS, you will make windfall of money, huge amount of money. But as you can say, countries such as United States of America and those developed countries, they can afford in order to buy those kind of medicines. When you come to countries such as low income, middle income countries, they can't afford such a kind of huge drugs. Then what government will do? Government will pay hefty amount of sum and then they will buy and then they will make generic drugs. Generic means a simple terms of drugs, just copy of that at affordable prices, at lower prices. That is mean of generic drugs. So we'll discuss this article in detail. Why generic drugs are very important in India's scenario, why drugs are very, very important, we will discuss this one. Generic drugs, they are very crucial for addressing healthcare affordability because those population who are marked with significant income disparities, these drugs will become very, very important. There are bioequivalent to branded drugs. These generic drugs, they offer cost-effective alternatives. India's leveraging economies of scale, low production cost, even to supply these affordable medications domestically, internationally. India is in a good position to make these kind of medicines. India can become, perhaps in COVID-19 situation, we supplied vaccines. We became leader in the world. We supplied vaccines at affordable prices. Even we supplied at low prices, even at free of cost to African nations. So you can understand those countries, they can afford from us. They can grow like anything. With out-of-pocket expenditure, almost 39% of the total healthcare expenditure in 21-22. These generic medicine, they reduce financial burden, they improve treatment adherence. By August 2024, generic medicines, they are worth almost 5,600 crores. They sold through Pradhan Mantri Bharatiya Jan Aushadhi Pariyojana. Almost they are over a decade, they consumed and they saved almost 30,000 crores. You can understand the impact. Recently, I went to buy paracetamol tablet. When I bought it from outside, I used to pay some 50 to 60 rupees. But I went to this Pradhan Mantri Jan Aushadhi Pariyojana. Those outlets, I got it for 7 rupees. I was shocked actually. So these kind of medicines, those people like us who belong to poor communities, we can be benefited very lot basically. Ensuring this quality of generic medicine in India, this is very important to make them affordable, even effectively to make as innovative drugs. Despite being bioequivalent to branded names drugs, quality control lapses have been occasionally compromised their efficiency and safety. There was a study by doctors of the Postgraduate Institute of Medical Education and Research, PGIMER, in Chandigarh. They published mycosis, basically investigating efficiency of the intracausal. This is one tablet in treating chronic pulmonary aspergillosis using some innovative drugs. 22 generic formulations have been formed. The innovator Itraconazole, they have achieved therapeutic drug levels almost 70% of the patients within 2 weeks. Compared to only 29% for generics, this makes required like 6 to 8 weeks. This dose escalation or even switching to innovator. Basically, what they are telling is when you put generic capsules, they prevent and they will have the same impact as normal drugs. But we need to understand why. Why do these generic and innovator drugs they differ in some cases despite being they are made from the same active ingredient? We need to understand generics they differ significantly in their XPC and even manufacturing processes. This leads variability in therapeutic outcomes. First thing, there are differences in excipients because there are binders are there, fillers are there, disintegrants, coatings. They can change drugs dissolution rate, stability, delivery mechanism. Whenever you take tablet, it should dissolute. If it is not dissoluting, then it can have like not the impact as normal drugs. Second thing, manufacturing process used in these generic drugs. They include like type of punching machines, compression force, granulation methods. They can influence the drug's physical and chemical properties. Variation in these tablet hardness, particular size, even porosity, they can affect disintegration in absorption also. In some of the cases, while these innovator drugs, they are designed to release API slowly in order to achieve sustained therapeutic effect. Generics, they may take a lot of time. It may take time for release of API. They potentially lead to fluctuation in drug level also. Third thing we need to understand, there are limitations of bioequivalent threshold of these generic medicines when it comes to regulatory standpoint of view. Because these medicines may not fall within the category of 80% to 125% of the innovator drugs range. These thresholds, they may be insufficient for medications with narrow therapeutic index. Even minor deviations in drug they release can lead to subtherapeutic effect, even adverse reactions also. Stabilizing these issues, it can reduce or prevent the drug shelf life, even reliability also. There is a key issue that lies in India's decentralized drug regulation system. This grants significant authority to state drug regulatory authority that leads to inconsistent enforcement, quality standards. If you see central government, we have Central Drug Standards Control Organization. They can only recommend action. This will lead to states to act. Despite repeated calls for centralization, crucial functions remain within the state. This enabling regulatory arbitrage because manufacturing exploiting these weaker outside. India, they must centralize drug regulation. We must strengthen this Central Drug Standard Control Organization with resources and personnel. And we need to establish more central drug testing lab in order to address this issue. Another reason in the inadequate enforcement of the stability testing to ensure drug efficiency and delivering climatic conditions. Basically, stability testing that has been mandated by Central Drug Standard Control Organization 2018. This requires those manufacturers, they need to demonstrate the drug maintain their quality, strength, identity under specified conditions. But inconsistent implementation by state licensing authorities, even absence is also clear. The centralized guidelines, they undermine compliance basically. Moreover, there is a lack of retrospective appliance of the generic approved before 2018 because these things will perpetuate substandard drugs in the market. It is a high time India must enforce these uniform stability testing protocols. Even we need to ensure centralized regulatory oversight, even mandate periodic reassessment of all approved generics in order to build confidence into drug quality. Thirdly, we need to understand India's pharmacanopia. Pharmacopoeia, this permits higher drug impurity when compared to United States of America and European standards also. This pharmacopoeia, there is a commission, pharmacopoeia commission, Central Drug Standard Control Regulation. They rejected stricter ICH guidelines because they are too expensive. Therefore, these standards, they should be made a bit more stringent. Even in that case, action must be taken to that level. These Pharmacopoeia Commission and Central Drug Standard Control Organization, even central government, they must involve all together and certain action should be taken. Centralizing this drug regulation, this will be effective with comprehensive overhaul of this Central Drug Standard Control Organization. Even it must be recognized in order to deliver robust regulatory safeguards. We need to protect patients from dangers of the substandard and counterfeit medicines through these strict regulatory protocols, effective inspection, even enforcement mechanism also. We must champion generics. They are indispensable for ensuring equitable access to medicines. But equity cannot come at the expense of the quality. State must prevent or remove their fragmented control over this drug regulation. There has been long undermined public confidence in generics. It is high time that we need to act on decade-long recommendations of the several committees. Bhatia committee in 1954. There was a Hathi committee in 1975. Even Mashkalkar committee in 2003. They all have called for centralized oversight. So it is high time that we need to act on these issues. We discussed 3 articles today. Thank you. Thank you very much for discussion.